Chapter 14. Judgments, Tax Liens, and Public Records. Let's talk first about what a public record is and how it affects your credit report. Then, we'll look at what you can do about it. A public record and freedom of information. A public record is information created by or for a government agency, such as a court, that anyone out there in the public can look up. It is not private or protected information. Technically, the government owns the recorded data. Access to the U.S. National Public Records is guided by the Freedom of Information Act. Here are some examples of public information, in alphabetical order: bankruptcy, criminal record, except sealed records. Judgment/civil judgment, licenses, tax record, vital statistics such as birth, marriage, and death. In some states, such as California, a marriage certificate may be marked confidential, in which case, it is closed to the public. Out of this list, do you know what is included on your credit report? You might be surprised. Bankruptcy is included. Criminal records are not included on a credit report, which is a financial record, but they can appear on an employer background report. An employer must have your signature permission to order a background report, and this permission must be separate from the application for employment, so no one can sneak it in with tiny print. Judgment/civil judgments stopped being included on credit reports in 2018. However, that is not considered a permanent decision, so they might be included in the future. Licenses are not included. Tax records are not included. However, if you have a tax lien against you, mortgage lenders will see it by doing a search of public records. It is not hidden information. Vital statistics, date of birth must be input to pull a credit report. Check your report for accuracy. Having an open judgment will prevent you from getting a home loan, so it is a key issue to explore next. Judgments/civil judgments. If a person owes a debt and does not pay, then they can be sued in a court of law to force payment. Both parties appear before the judge with what evidence they have and present their cases. If the judge determines money is owed, then that becomes a judgment and public record. If one party does not show up, they automatically lose. Never be a no-show. That is exactly what the greedy collectors who tack on fees and interest to double the balance want. The bottom-feeding collectors who buy debt that is past the statute of limitations for 1 penny on the dollar also want you to be a no-show. That is their entire plan. You don't show up to say the statute of limitation has expired, and they don't bring it up either. Next thing, they win by default. The judge never defends you. The judge always allows them to win if you're absent from the hearing. In the past, the judgment also went on the person's credit report, but as of 2018, the credit bureaus declared they would remove most judgments from credit reports and not post any new judgments, for a time not specified. In the future, they could resume posting judgments on credit reports. Just because the judgment does not show on your credit report does not mean the creditor can't still come after you for the money. They can and they will. With a written judgment in hand, the creditor might go to your bank and withdraw funds. Or the creditor might go to your employer and set up an automatic withdrawal of funds from your paycheck. You will learn of this when you see your next bank statement or when your next paycheck is smaller than you expect. That would be a rude awakening. It's happened to a lot of people, and you don't want it happening to you. This is why you must never ignore a threat from a creditor to take legal action. If you receive a phone call or piece of mail stating pay or else we go to court, then you need to respond immediately. We'll talk about what to say and do in a moment. But first, there is more to understand. Creditors, employers, and landlords easily discover judgments by searching public records. You can do the same by going to the government website, pacer.uscourts.gov. PACER stands for Public Access to Court Electronic Documents. Obviously, never lie on an application about having a judgment filed against you. There is a question on the mortgage application that asks if you have a judgment or tax lien. Checking the box for no is felony fraud. One of my mortgage colleagues had a client who failed to disclose his judgment. When the underwriter checked Pacer and asked whether or not it had been paid off, the loan officer had a conversation with the client. "Is this judgment yours?" he asked. "Yes." "Why did you check no on the application and why didn't you tell me about it?" "I didn't think anyone would find out," the client said. That story did not end well. Not only was the client denied the loan because he did not have sufficient funds for the payments, but also, the mortgage broker was required by law to file a suspicious activity report on the client. What's more, the law states that the loan officer is not allowed to tell the client that a suspicious activity report is being filed on them. It is kept on record in case there is evidence of a worse financial crime such as money laundering or other fraud. Let's say there is a case where the judgment is not disclosed on the application, and the underwriter did not search Pacer or find it. That happened to one of my personal clients. Everything was going along as smooth as a ride down a lazy river. We got final approval, and the clients met with the escrow notary. All documents were signed, sealed, and delivered, as sweet as a Stevie Wonder song. But then when the deed of trust went to the county for recording, they hit a brick wall. The deed could not record because there was a judgment against the client for an old, unpaid debt. It was awful. The loan could not be completed until they could get a gift from family to pay the debt. The family member had to sign the official gift letter, and the loan had to go back in line to underwriting. By this time, the documents were out of date, so we had to get an extension and reprint documents for a new signing. Finally, the loan did close, but it was not a fun experience those last few days. So, if anyone tells you that a certain lender won't check or won't find out, don't be tempted to go down that path. Always tell your loan officer the worst part about your credit right up front so your loan officer can help you handle it in the best possible way. Your mortgage broker is your advocate, your friend in the business. Getting a mortgage with an open judgment. Here's some good news. You can get approved for an FHA loan even with a judgment as long as you have a payment plan in place and have made 3 consecutive, on-time payments. Then underwriting looks at it like any other normal debt and factors the payment into your outgo ratio. You cannot make 3 months' payments in a lump sum to speed ahead, so a little planning is necessary. With a conventional loan, backed by Fannie Mae or Freddie Mac, the judgment would need to be paid off before or through the closing. Many lenders require it to be paid off before, so you'll need to show proof of payment if the public records haven't been updated to a zero balance. Other consequences of an open judgment. Landlords and employers also check public records. You don't want to lose out on a great apartment or rental home. You don't want to miss a lucrative job opportunity either. Depending on your state, a judgment can stay on record for 10 to 20 years, and sometimes the creditor can renew it to stay even longer. The sooner you take care of the judgment, the better. These are 2 more reasons why taking care of a judgment sooner is better. You never know what possibility might come across your path. The girlfriend's judgment. I know a young woman who filed a judgment against her former boyfriend who owed her $1,200. The last straw that really set her off was when she found out he participated in a fantasy football betting pool but had not repaid a single dollar to her. It was easy. She had a sheet of notebook paper where he'd written down that he would pay back $1,200, and she knew where he worked. She found a licensed collector who agreed to take the debt for 30%. She figured something was better than nothing, and she wanted him to pay. The collector promptly got a judgment in small claims court and proceeded to garnish his wages. On payday, the boyfriend called her on the phone, ranting, but there was nothing he could do to stop it. She got $800 and a big dose of satisfaction, and the collector got $400 for a couple hours' work. This is how the story was told to me. I am including it here in case someone owes you a significant amount of money, is not paying, and you need to take the next step. You want to get something in writing with a signature that states the amount of the loan, if you don't already have it. Seek advice from a local collector or collection attorney. Refuse to be a silent victim of a liar or fraudster. Don't hold in resentment, that leads to stress, insomnia, and negative energy. At least find out what your options are. Then learn a life lesson so that you don't repeat the mistake. A civil judgment is a debt owed through the court. How to handle a judgment with a balance. If you discover that there is a judgment against you, then the best thing to do is to contact the person or company that filed the lawsuit to work out a settlement. The settlement must be in writing. Try to negotiate a lower amount to pay, especially if the balance includes late fees and interest. Your agreement could be a lump sum payment or monthly payments. Often, they will agree to a lower amount for a lump sum so that they can collect and close the account sooner. Make sure your agreement includes that they will report the account as paid in full with a $0 balance to the court so that an open judgment doesn't remain on your record. Never believe a promise to remove the judgment from your name if it is not in writing. Some people will say anything to get money, but after the funds are in their hands, they suddenly get lazy and never bother to follow up. You must keep all of the written records. Do not give them your bank account information. Why would you ever let your opposition have access to your bank account? Pay by check and make a copy or photo for your records before sending it. Write paid in full as agreed on the front of the check. You can also pay by money order or cashier's check in the same way. Keep a copy of these 3 items: 1. The written agreement, 2. The check, and 3. Your bank statement showing the funds withdrawn, with the dollar amount matching your check. You might need to show an underwriter or lender proof of payment. Proof is not the front of a check. Anyone can write a check, take a photo, and then tear up the check later. Proof is the check matching the funds withdrawn on your bank statement. Don't pay by a paperless, digital method such Venmo. If you were never served notice. A surprising number of people say they were never served notice of a court hearing until after they discovered a judgment was posted against them. It is illegal to post a judgment against you without having provided proper notice either by mail or in person. The creditor or collector cannot send a letter to an address where you never lived and then speed through the system and grab money out of your paycheck. If something like this happened to you, then you need to contact a local consumer protection attorney so they can file a motion to vacate or set aside the judgment in the same court where it was filed. Each state has its own laws. I am not an attorney and do not give legal advice. I am encouraging you to know that a judgment in which you were never properly served can be voided by the judge, but you need to go through the court to make that happen. Your attorney can request that the company or person who executed the illegal judgment pay all attorney and court costs. Tax liens and back taxes owed. If you owe on federal taxes, you have options. First, the IRS offers an installment agreement, which is a plan for you to make monthly payments. When you have made at least 3 consecutive, on-time payments, you can get an FHA loan to purchase a home, provided all other requirements are met, including the 3.5% down payment and showing you can afford to pay your monthly obligations as well as the new mortgage payment. You can learn about the IRS payment plan here, irs.gov, look for Payment Plans Installment Agreements. Second, if you are completely buried in debt and cannot afford a monthly payment, the possibility of filing bankruptcy on IRS tax debt is worth exploring with a local bankruptcy attorney. No one should sink into depression over taxes. Because liens are no longer posted on credit reports, it will not negatively impact your credit score, for now. There is no guarantee that liens will always remain off credit reports, so I wouldn't be surprised to see unpaid taxes post again in the next few years. If you received a temporary suspension for paying the IRS taxes during the pandemic, that period of grace ended at the end of 2023. If you receive a notice from the IRS, you must not ignore it. No one has more leverage against a debt owed than the IRS. They don't forget or let it go. If you receive a letter from the IRS, make it a priority to respond immediately. If you cannot pay the sum, then work out a monthly payment plan, as mentioned above. Whatever you do, don't get overwhelmed, discouraged, and then ignore taxes owed. So many people owed the IRS money, but then they got settlement agreements they could manage and pulled themselves up out of the hole. There is light at the end of the tunnel. Never lose sight of the light. Coming up next. A credit repair attorney I know calls collections low-hanging fruit. Let's see why, ahead.